Hello, everyone. Welcome. My name is Vilerka Bilbao. I am an immigration attorney out of Jacksonville, Florida. I have a firm called Bilbao Law, and we help defend immigrants and their human rights. Today, I want to talk about three big changes in immigration law. The first one, the DACA decision that we recently heard. The second, changes in asylum law that are coming up in August of this year. And third, handling a visa overstay during COVID-19. So during this little presentation, I will be taking any questions, any live comments of anyone who's on there. So make sure to follow our page, make sure to write on there any comments that you have, and we'll be answering those live. Let's start then with, from our three big changes in immigration law, let's start with the DACA decision. As many of you might have seen in the past weeks, the Supreme Court finally made a decision on DACA. DACA was a program that was implemented so that people who came to the United States as children through no fault of their own could obtain some form of legal status and be able to remain in the United States, not be deported, have a driver's license, get a work permit, and be able to go to school. And so when this administration came into power, one of the things that they did was remove the DACA decision. And so what the Supreme Court said is that the way that this administration removed the DACA program was incorrect. They didn't follow all of the protocols. They didn't give correct justification for eliminating the DACA program. And so what that means is that DACA is now still standing. People can apply for DACA. People can renew their DACA status. So I want to talk a little bit about what does it mean to have DACA status and what requirements you need to apply. So first, if you came to the United States before you were 16 years old, and you have been living here in the United States without ever leaving since June 15, 2007, and you've either gone to school, gone to high school, gotten a GED, or are in school, and you have no felony convictions, then you are eligible for DACA. And I'm gonna repeat that. So if you came to the United States before you were 16 years old, you have been in the United States since June 15, 2007, you've never left, and you've either completed high school, completed your GED, some kind of training, even some kind of military training, or you are in school and you have no felony convictions, then you are eligible to apply for DACA. And it's extremely important that if you do not have status and you qualify for DACA, that you figure out how to obtain that status. Because when you get DACA, what that means is that you will have a work permit to be able to work legally in the United States. You will be able to have identification documents. You will be able to go to school, get in-state tuition in most schools, and you'll be able to live and work freely in the United States without fear of being deported. Because part of what DACA does, it's called Deferred Action for Childhood Arrivals. What that means is that you are not going to be placed in deportation proceedings. So that's a huge protection once you have DACA. A lot of people prior to the Supreme Court case had the DACA status and had not renewed it. This is the time to renew. It's very important that you do so. With immigration offices closing and immigration officers being furloughed, more than 13,000 of them were sent home in the past week. All of these applications are going to take a very long time to process. And if you need to renew, the immigration office has said that they will use your existing biometrics, fingerprints, and photos to renew your application. So those are coming in relatively fast. Okay, if you need help with this process, I suggest that you contact an attorney, a licensed attorney in your state to help you, because you don't want to ruin this process and you don't want to spend extra time and extra money doing this. You can call my office for a consultation. We have people available to take your call today. My phone number is 904-300-0825, and it's on there on the screen for whenever you need it. Okay, so that was our big topic number one, DACA and the changes, which is really, really good news. A lot of immigration attorneys and immigration advocates have been celebrating because DACA is here to stay. And there is some rumors that that Congress will pass some laws that will make DACA officially a pathway to citizenship, where DACA recipients might be able to get a green card and eventually become citizens. So we're hoping for that. Please be on the lookout for that. So topic number two is big changes in asylum law that are coming in August, specifically August 25th of this year. So as many of you know, if you are immigrants or if you have any family who may be seeking asylum, asylum is a protection that we give to individuals who have been either persecuted, tortured, or harmed by their government or by someone that governments fail to control. And so people flee their countries and come to the United States. They can go to Canada, they can go to other countries looking for help, looking for refuge, looking for asylum. And since this administration has taken power, they have reduced a lot of the asylum protections. One of the things that they've done is they've reduced categories of people who can potentially get asylum. And now one of the big changes that are coming is that if you are in the process of asylum and you entered the United States without coming through a legal port of entry, which means you either crossed the border or maybe came in hiding on a ship, that you will not be eligible to receive a work permit while your asylum case is pending. And this is big, big news, because in the past, you were able to apply for asylum, and after 6 months, if the government had not made a decision in your case, you were able to get a work permit. You were able to remain here while the government made a decision. And our government is not very efficient. One of the things that they do is they take a long time to make decisions. Some cases can be pending for 1, 2, 3, 4, 5 years with the immigration office or even in the courts. And so now those individuals who apply for asylum may not have access to a work permit, to an authorization to work while they are here in the United States waiting for a decision from the immigration office. A lot of immigration attorneys and agencies that protect immigrant rights are criticizing the government's decision to do this because it will leave a lot of people homeless. So if you have not yet applied for asylum, if you have a fear of returning to your country, one of the things that you need to do is apply as soon as possible. This rule is supposed to take effect on August 25th of 2020 of this year. And so if you apply after that time, it may be that you will not have access to have a work permit while you wait for your decision to be made. And we know that, one, immigration has already been extremely slow in making decisions. Two, that with all the COVID and the coronavirus closures, the offices are taking even more time to make decisions. And three, the immigration office recently furloughed at least 11 or 13,000, I think it might be, employees from the immigration office. And so that means that cases are going to be even slower. So a delay that could have been 2 years can now become easily 2, 3, 4, 5 years. So it's very important that if you know someone who is in fear of returning to their country, that you tell them that they contact an immigration attorney to help them with the asylum process. And one more thing that I would say about asylum is that asylum is a complicated process. It's not easy. You just don't tell the government that you're afraid to return to your country. They don't take your word for it. You have to submit a lot of evidence. And so you have a lot of time to submit that evidence and work with an attorney to create a really good package, but you need to submit your initial application before August 25th so that you don't run the risk of not having a work permit during that time. Okay, so let's talk about our third big change in immigration law, and this has to do with visa overstays during COVID-19. So traditionally, a visa is a permit to come into the United States for a temporary time. Some people get a visa for tourist purposes, that B1, B2 visa, where you can come in and go to Disney, as I'd like to say, or you can go and visit New York or go to California. You usually have to show that you're going to come here for a vacation, maybe for a wedding, and then you're returning back to your country. There's individuals who come in with a visa for business purposes. They come here because they need to sign some deals. They need to purchase a business or sell assets. There's many, many visas. There's visas for artists, for students. But what is happening now during COVID, during the coronavirus pandemic, is that a lot of people cannot travel back to their home countries and they have to remain in the United States. And if they do that, they may be overstaying their visa. And there's a big, big problem with that. If you overstay your visa, that means that you may not be allowed to come back in. Your visa may be revoked. You may not be allowed to come back into the United States at a future date. So there is something that you can do to help yourself and make sure that you don't have any negative consequences, especially if your country is not accepting flights right now. So for the first thing is you have to submit an extension of your visa. That is, you do that with Form I-539. And you have to do that and you have to document to the government that you didn't have any flights, that you really couldn't leave the country. And you have to have that documentation submitted to the government and keep a copy for yourself. If you don't do this, you run the risk that you can leave the country without a problem, but next time that you come in, that an officer either deport you right away or send you back to your country, or they take your visa away completely, or they deny you future renovations or renewals of your visa, or deny you any type of immigration benefit in the future. So it's very important that if you have a visa, you're in the United States and you're not able to leave due to COVID, that you fill out one of these applications and you send it to the immigration office. All of the instructions are found on uscis.gov. It's the immigration office website. You can Google it. It's extremely easy. You can follow the instructions on there. I do recommend, though, that you use an attorney for this process as well, because there are consequences. You can say something wrong. You can put in wrong information in there, and that can lead the immigration office to deny your case at some point. Okay? And one last thing about these visa overstays. Remember how I mentioned that the government is extremely slow in processing everything? Do not expect a response from the government. You have to file before your visa expires, before your time to leave is up, but do not expect an immediate response from the immigration office because they are very, very slow. So long as you submit it in time, you can show that you are doing the right thing, but the immigration office may take 6 months, 9 months, 10 months to respond, okay? It was a pleasure speaking with you all today. Again, my name is Vilerka Bilbao. I'm an immigration attorney. If anyone has any questions or would like a consultation to speak about their case in particular, you can call my office, 904-300-0825. You can also visit our website at bilbaolaw.com. Follow us on YouTube, Instagram, and Facebook. Hope to see you guys around.